Welcome everybody. This is a great turnout. Obviously, very pertinent topic right now. Want to introduce myself so people don't know. My name is Ryan Poole. I'm an active real estate agent, just like you in the trenches. Been doing this for over 20 years, and I have the privilege of co-hosting this bi-weekly webinar with Jim, real estate attorney, a founder of New Path Title and awesome closing software Title Leap. I'm also the founder of RealTrade, which is an online marketplace and social media platform for real estate agents. It's a place where you can get direct leads and connect with other agents and awesome service providers like Jim. So we want to add value to you agents. One of Jim's favorite saying is "iron sharpens iron," right where we can learn from everybody. And this is a very, very important topic. This is a big change. I've been in the industry, like I said, over 20 years. And this is one of the biggest changes I've seen in my time as being a real estate agent. So it's pretty awesome that we got Jim, here, a real estate attorney that's going to go from an attorney perspective covering this topic. So it's pretty exciting, Jim. So go ahead, Jim. Why don't you introduce yourself and get this thing started?
Thanks, Ryan. All right, you guys, I want to start by saying this is a discussion where our goal is to provide you information that you won't hear anyplace else, right? So everybody, is there somebody who can mute?
Yeah, I'm just trying to see who's speaking. We can mute.
So there's a million places you guys can go for information. What I try to do is try to find unique perspectives and ways that you guys can work within the rules. I won't tell you how to bend the rules, but I'll tell you where I think the rules end and what kind of leeways or what kind of discretions we can use in making transactions happen. There are no dumb questions, you guys. Anything you want to put in the chat, let's get to this stuff. Text me 24/7. You can go to newpathtitle.com. You got access to me all the time. We want to get through this in about 30 to 45 minutes. There is a lot here. I wrote most of the day yesterday. I've been researching for the last 2 or 3 weeks. Like literally, when I ride my bike, I listen to long podcast discussions on the topic. I've been reading everything I can read. I just finished writing 2 minutes before this session started. I don't even have a headline or a footer on my outline. So we're going to try to keep this short. I'll go into the new forms in a second. Turn on your camera. It's great if I can see your reactions. We're going to have a question and answer session at the end, and then Ryan's going to drop some time-saving tools on you guys. And again, text me for any future topics. Go to newpathtitle.com. My text number is available right there. Title advance is available, but feel free. Like Ryan led with, iron sharpens iron, right? My best information comes from you guys. And everybody who texts me says, "Hey, I know you're busy. Sorry for the imposition." Here's the reality. I'm busy. Thank you for the imposition, because it just gives us all the information we need and food to move forward so we can all educate each other. Iron sharpens iron. Having said that, was there anything you wanted to say leading into this, Ryan?
Yeah, just as we go through, if you have any questions, put them in the chat. We'll try to get to them then, or we can answer them at the end. We want to keep this an open discussion. As Jim said, we can learn from each other on this. And it's a very big topic, Jim. Excited for this one and hear your perspective.
All right, let's get the share screen going. I'm going to do something a little different today. I'm going to share 2 screens at once because I'm going to share my outline and I'm going to share the notes that I made on the form. Can everybody see my outline? Can everybody see the form?
Yep, I can see it, Jim.
Yes.
All right.
Yeah.
So today the date's obviously July 16th, and the agents are buzzing about Censor Burnett and rule changes that are all coming down August 17th. In July 2024, the Florida Realtors released a new batch of forms for agents to use to implement the rule changes. This discussion goes through some of the new forms. There's more forms coming. This is just some of the new forms. And I'm going to make this outline available on our website so you don't have to write anything down. And as those new forms come through, we're going to start exploring those new forms. There are more forms being dropped July 23rd. My goal is always to give you guys perspectives that you won't get anyplace else. What are the 2 biggest rule changes? We all know what they are. No more listings of buyers' compensation in the MLS. And all NAR member agents have to get signed buyers' engagement agreements from buyers before they show them property. There is still some discussion that this may not get ratified, right? So this is preliminary approval. The court hasn't given final approval, and And the Florida Association of Realtors is literally sitting back to see if this thing doesn't get repealed and the date pushed forward. Having said that, I wouldn't do anything any differently. You guys have to behave as if August 17th, these rules are going to be implemented. Some agencies are already doing this stuff ahead of the curve. And for that reason, I would not hold your breath and say, we're going to wait till the end. This discussion focuses on the two rule changes. There are two batches of forms. So there's two batches of forms that were distributed earlier in July. The revised buyer brokerage agreements. There are 4 forms. If you guys don't think this is confusing, please call me and tell me, because this is confusing, but I tried to make it as easy as I could. There's 4 buyer brokerage agreement forms. There's 2 new sellers compensation forms. And we can go over, if anybody hasn't seen the index in the forms library, you're going to see there's 2 new sellers compensation agreements and 2 modification forms to these agreements. The buyer's engagement agreement forms. These forms were revised and published early in July. A written engagement agreement is necessary before an agent can tour a property with a buyer. These forms are what buyer's agents use to sign a buyer's, all the obvious. These forms define the work and maximum compensation between buyer's agents and buyer. These not only define the work, these define the work and then duties and maximum compensation. Doesn't mean you can't take less compensation, but you can't take more. We'll talk about that more in a bit. Unfortunately, the main title on all these different forms, so there's 4 buyer's agency agreement forms, but they don't put the subject on the first page of the form. So I'll tell you an easy way to identify these forms in a minute, but if you're frustrated like I was trying to figure out the difference between the forms, I don't know whether this was done intentionally or not, but it is frustrating. So you have the exclusive buyer brokerage agreement, single agent. You have the exclusive buyer brokerage agreement, transaction broker. If anybody on this session has information that I'm not relaying as to the use and application of these forms, absolutely chime in at any time. Then you have the exclusive buyer brokerage agreements transition to transaction broker. And you have the exclusive buyer brokerage agreement non-representative. The first 2 pages of all 4 brokerage forms are the same. Page 3 is where each form differs in application, but page 1 doesn't state what the application is. Most brokers I've talked to are using the transaction broker form. That's this form right here. I call it number 2. Lots of brokers suggest starting with 1 year. So now when we're looking at the actual form, you're going to identify this form. Can you guys see the form on the right screen?
Yep. Yes, we can.
You're going to identify this form most readily by going to the top.
This is the contract.
Recording in progress.
So here's your form library, listing an agency. So if you come down here, you've got the single agent, the transaction broker, the transition to transaction broker, and non-representative. I'm going to focus on non-representative and transaction broker. And here's the 4 agreements that we talked about earlier in the discussion. These are the new forms altogether. So we're going to click on the transaction broker form. They all start out the same way. You'll know you're on the transaction broker form when you get to the top of page 2, paragraph 12. It's in the outline. It's going to say broker will act as a transaction broker.
Yeah, it's on page 3, Jim. Yeah, on page 3 it says. Top of
page 3. What did I say? Page 2?
Yeah.
Yeah, top of page 3, paragraph 12. Now you have to do whatever your broker says. I'm giving you the information that I've heard from the majority of brokers that I've heard from. I've had personal conversations and I've listened to a million discussions and I've done as much reading as I can. This is what they tell me. But if your broker says they want you to start with a single agent agreement, that's what you have to start with. But all the different agreements are defined in paragraph 12. start by making your agreement as broad as possible. So you have the term and you have the property. Lots of agents I've talked to, lots of brokers I've heard from, they say they're going to start with 1 year, and they're going to start with Florida, and they're going to start with residential and commercial. You have to, I think as a practitioner, you have to figure out what you're comfortable with. And certainly if you start with those terms, your buyer could walk it back if they want. Hey, I'm looking at property in North Florida, and we have our own agent, and that's fine. You would then figure out how to adjust and be agile from there. But you're going to start by saying, and your broker might tell you something different, you guys. This is all my opinion. Your broker could say, I want you to start with Palm Beach County or something. So that's stuff you have to weigh in with your broker on. So that's how you start with the term and the property. I would keep it as broad as possible. Buyers are on notice. Agent can work with other buyers on the same property and requires agent to give notice. So this is a little bit different. There's a provision in here that puts the buyers on notice because there's lawsuits about conflicts with agents corrupting the position of buyers by working with multiple buyers on the same property. And now that's all spelled out in the agreement to the benefit of the agents. There's lots of good stuff in this agreement for agents. I personally feel it's too long. I personally feel it's too wordy. There's an EXP agreement out there that's circulating that I think does an adequate job, and it's a lot shorter. Regardless, this is what we have to work with right now, and this is what the majority of brokers are requiring their agents use. Even a lot of the EXP agents or brokers are requiring that the agents use the Florida Association of the Florida Realtors form. So they're on notice that you could be working with multiple buyers on the same property. This ends the perceived conflicts that have come up in the past. And as always, agents can't reveal the terms of other deals. So if a buyer's agent is working with several buyers on the same property, obviously you can't reveal the terms of those deals, but you have to reveal to your other buyers that you're working with. You have to reveal to your buyers you're working with other buyers on that property, same property. There's new protection against referrals to vendors. We have cases where parties sued agents for bad inspections, and that just happens. I don't know if you guys have any knowledge of that, but there's a new provision in the contract, the buyer-broker agreement 4D. Broker does not warrant or guarantee products or services provided by third parties whom they give referrals for. That's a big win for us. That gets you out of potential conflicts much quicker. There's a new provision requiring buyers to tell sellers and sellers agents they have a buyer's agent. So in here, there's a obligations section, and bing, 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 for our benefit. It says here, if consumer, they call buyers consumers. If consumers contacts, or if consumer contacts or is contacted by an owner or real estate licensee who is working with an owner or views properties unaccompanied by broker, consumer will at first opportunity advise the owner or the licensee that the consumer is working with the buyer's agent. Now, if they do this, they do this. If they don't, they don't. They're contractually obligated to do it. And so there's a lot of discussion about agents getting tougher on commissions when they get beat by their clients. And I don't think that's a bad thing. Do I want to represent a bunch of realtors in commission lawsuits? No. But I also feel like agents work their butt off, and you shouldn't be beat by buyers looking to not pay you. And I'm passionate about that. That's something that I feel deeply about. I feel like every time we come to a closing table and I see a buyer's agent or a seller's agent making concessions, I want to help them, because if things had happened further upstream, they wouldn't have been making the concessions at the closing table. And by the same token, if buyers are running around trying to not pay commission to buyer's agents, I want to make sure that buyer's agents are getting paid in those circumstances. A credit check is new.
Yeah.
I don't know if I like that. So here it says, providing broker and necessary third parties. These are the duties. And it says that provide broker and necessary third parties with accurate information you requested by broker or third parties in connection with ensuing ensuring consumers' ability to acquire the property. Consumer authorizes broker to run a credit check to verify consumers' credit information. I would like it if that wasn't in there, because that implies the door is open, and then if you don't do it and something boomerangs as a result of bad credit that could have been discovered earlier, I could see somebody saying, well, the agent should have known. And that makes me uncomfortable, but I'm not gonna belabor that too much. There's a new section that the relationship is locked in. We don't have to, agents no longer have to be available. I say we, because I feel like an agent. Agents don't have to be available 24/7. I suggest you give all buyers a Calendly link. So there's a provision in here, being available to meet with broker at reasonable times for consultations and view properties. Reasonable times. You're already locked into this agreement, right? So before, you would want to run around at the whim of your buyer. Every impulse the buyer gave you, they had an idea about seeing something. So now you're dropping everything to run around. Under this agreement, you're locked in. They can't run around without you. They need to go to your Calendly link and schedule a showing. Now you're not at their whim so much. Those are the discussions I've heard. I'm sure agents will still be the best agent they can be, but at the same time, you have a feeling of security because your transaction is blanketed in this agreement that they're not going to usurp you. If anybody has any strong objections to what I'm saying, I'd love to hear it. Say that again, Ryan.
No, this is great, Jim. I mean, we're getting into the nitty gritty and details of this agreement, and it's important.
Yeah. So indemnifying and holding broker harmless, there's a new section. Holding broker harmless against all losses, damages, costs, expenses of any kind, including attorney's fees, and from liability to any person that broker incurs because of acting in consumer's behalf. That's a super broad statement. I like the way it sounds. I wish it had more meat on the bone, but I like the sound of that. So you give somebody advice and you say, this crack in the slab isn't as serious as it looks. First of all, there's a provision in the contract, the new agreement that we're going to go over in a second, that requires they get experts. Second of all, they can't come back and say, well, the broker told me, and I relied on what the broker said. They're indemnified. They're giving you their opinion. They're not making guarantees. They're not making affirmative representations. And this contract affirmatively tells buyers that you're not liable. Love it. Again, I wish it had a little bit more bone. I wish I had a little more meat on the bones and was a little more specific, but I love it. Not asking or expecting or restrict the acquisition of property, so that's obvious. Consulting the appropriate, here's the one I was looking for. Consulting an appropriate professional for legal work, environmental engineering, foreign reporting requirements, and other specialized advice. Foreign reporting, foreign buyer rules, right? I have seen so many agents misstate the foreign buyer rules. Under that first paragraph that we just went over a second ago, agents aren't liable. Now that doesn't mean you can make misrepresentations, but you're not going to be liable for, there's a ton of facts that are important in these things, right? In a small conversation, agents can't get to the bottom of specifically these buyer's agency, these foreign buyer rules. And now there's a specific statement in the relationship with your buyer that says they're going to go out and hire an expert who can give them advice on that very complicated law. Again, I love it. There's a new section on buyers can't ghost agents and not pay the agent. So here it says, make a good faith effort to perform the contract terms of any purchase agreement or contract to lease and close on the sale of the property. This is what the buyer has to do. They can't just ghost you and not pay you. They have to make a good faith effort. There's a section in here on a retainer. If anybody wants to speak up on retainers, I hear agents tell me specifically in more expensive markets that they get retainers. I've heard an agent tell me they always get retainers up in the Gold Coast. I personally see it as a hurdle. I don't see it happening, but I have heard agents say they do it. And then the issue becomes, are you going to credit the retainer towards the commission if they close, or are you not? The standard provision in the contract is that you're not going to credit them for the value of the retainer. So if they all use $5,000 in commissions, you took $1,000 retainer, you'd be getting a $6,000 payday. Does anybody have any questions on that? Does anybody have any elaborations they want to go to on that stuff?
No.
All right, the compensation section, very important. Compensation is earned specifically when the contract is entered into. So compensation, broker's compensation is earned when during the term of this agreement, a renewal or extension, consumer or any person acting on behalf of consumer contracts to acquire real property. Contracts, not closes, as specified in this agreement, or defaults. I don't know why they threw the defaults part in there. You don't have a default if you don't have a contract. And if your compensation was earned when you got the contract, it's already earned. The default is irrelevant. Does everybody follow what I'm saying? You earned your compensation when you guys got the contract. It's as simple as that. I don't know why the default provision is in there. Make sure you point out any compensation paid by seller or seller's agent reduces what the buyer owes the buyer's agent. Think about this like a doctor's agreement. This is a part of the form when you're doing your buyer's engagement meeting that I would bring out and I would highlight. Let's see, where is it? Compensation received by broker, if any, from an owner or owner's broker for services rendered to consumer will reduce any amount owed by consumer per this paragraph. So whenever you go to the doctor's office, you always sign an agreement that says, whatever my insurance company doesn't pay, I will be responsible for. I would, when you're explaining this agreement, point out that paragraph, point out that sentence specifically, or have it highlighted or something in your form, and say, when this is just like the form you sign every single time you go to the doctor's office. It's no different. I'm not saying we dumb it down. I'm just saying you normalize it. These are not unusual agreements. These are just like the doctor's agreement you signed last time you went and every time you went to the doctor's office. And if you have kids, you sign this once a month. And if you got a bunch of kids, you sign it a couple of times a month. Pablo's laughing. How many times do you sign that thing a month, Pablo? No more mention of commissions. Very, very, very important. No more talking about commissions. I like the form. I don't like the form because it's long. I like the form because it gets realtors, agents out of situations I've seen them incur liability, but I do not understand why we had to make this leap to consumers instead of buyers and compensation instead of commissions. And when you talk about seller side, it's called marketing fees. So for whatever reason, and there are going to be plaintiffs' attorneys from large law firms posing as buyers and sellers, and they're going to call you. They're called testers, and there's going to be compliance testers that are going to call you posing as buyers and sellers. You have to make sure that you refer to fees paid by buyers as buyers' compensation. And you have to make sure you refer to fees paid by sellers as marketing fees. I don't know what the penalties could possibly be, but in all the discussions I've seen, they stress the importance of this. I hate to make something important that I think is trivial, but I'm going to tell you guys what I've been hearing. Brokers have told me they are going to sue on these agreements for buyers that go radio silent or try to close without telling the buyer's agent. I've been doing this for 40 years. I've been working intensely with agents for 20 years as a solo practitioner. I've always heard from agents the same thing. Hey, if they don't close for me, I don't want to create bad blood. And I appreciate that. I agree with that. I don't want the bad press for suing over commissions. If I would not want it if I was an agent. However, I will say I've heard a ton of brokers discussing we're going to now go after our buyers that try to usurp us because we have a written agreement. That's totally up to the agent. It's totally up to the broker, but I have heard that a lot. And I will say that I am not in disfavor of that. What's up, Pablo?
Oh, before this about the broker's agreement, I have a broker, a friend of mine. I believe he's with EXP, and he was having, even before this, 4 or 5 years ago, he was doing a buyer agreement. He was putting like $2,000 or $4,000 fee if they buy with somebody else. So all his buyers sign it. Some of the buyers, someone say, I don't want to buy anymore. Then they figured it out like a couple months later, they bought with somebody else. So this guy is honest. So he was just going through the court records and seeing who closed. One of the person he go and saying request a payment while leaving the house, and they're paying. You know.
I heard a whole discussion about agents, brokers, broker to brokers, talking about how they could have their transactions coordinators do exactly what you're talking about. Scour the public record, figuring out who closed, cross-reference with your data sheet, your database, and going after and saying, hey, I see you closed, you owe me my money. Listen, you guys, we live in a litigious society. I'm going to tell you something that I don't really say out loud much. I don't really like lawyers. I don't like lawyers. But what I do like is business. And I like if people I like contracts. And I like if people enter into a contract, I like good faith people having an avenue for relief.
We don't like lawyers until we need one.
Yeah, it's like cops, right? Nobody likes the cops. They gave me a ticket, they did a this, they did a that. As soon as somebody breaks into your house, who you call? Come on, you got to help me. They broke into my house. You call the cops. So I don't like lawyers for the most part. I think there are some great transactional lawyers in Palm Beach County. I think they get deals done. I think with the new buyer's agency forms, we're going to get into it a little bit. I think that dual agency can absolutely happen, but there's some steps we're going to have to take. We'll get into that later on. But suffice it to say, brokers have told me that they're going to be taking action on these agreements where buyers ghost them or they see that they've closed. And the limit for small claims court is $9,000. Most of a lot of these would fall under that category. They don't need lawyers. Again, I don't endorse it. I endorse it. I don't like it, but I also think it's important that people not take advantage of agents. The protection period. Lots of agents have told me they're going to use 90 days. There's a protection period in here that defaults to 30. I wish I had a way to highlight the form, but I don't. The protection period defaults to 30 if you don't write something in. It works just like the listing agreement. If a buyer's agent during the protection period goes up and signs up with another buyer's agent, they could usurp paying buyer's agent A. What do I mean by that? I saw this several times recently where the seller would, in a listing agreement format, they saw a seller and the seller's agent negotiate a termination. So they've terminated the listing agreement, and then the buyer goes and then the seller goes and sells to somebody that was shown the property during the term of the listing. And what they did was they went out and the seller hired a flat fee broker, cut off the rights of the listing agent A, and didn't pay the commission to listing agent A. We went over that a few times or in earlier podcasts. If you guys have any questions, let me know about it, or just text me and we'll talk about it more. But basically the same provision exists in this agreement. So what could a devious buyer's agent do if they wanted to? Terminate your agreement, go sign up with their buddy for $1, buy the property and not pay anybody a commission. Does everybody follow that?
Yeah.
Yeah, you can do a signed contract too, right?
Well, what I'm saying is, in the way this is written, let's read it out loud. Consumers request broker may agree to conditionally terminate this agreement. If broker agrees to conditionally terminate the agreement, consumer must enter into a written agreement to this effect and pay a cancellation fee of X. You know, you can come up with the X later, you can come up with the X now, but it's in the form. Broker may void the conditional termination and consumer will pay the fee stated in the compensation paragraph less the cancellation fee from the early date of the termination date plus the protection period if applicable if consumer contracts to acquire any property which prior to the early termination date was found by consumer or called to consumer's attention by broker. That's pretty self-explanatory. The protection period says the consumer will compensate the broker if between X days after the termination date, consumer contracts to acquire any property which was called to consumer's attention by broker or any person or founded by consumer during the term of this agreement. Consumer's obligation to pay broker's fees ceases upon consumer entering into a good faith exclusive buyer brokerage agreement with another broker after the termination date. Now it says good faith, right? And so I could argue if they go up and sign up another buyer's agent for $1, that's bad faith. But it's there and it's just another opportunity to negotiate. If I were doing buyer's agency agreements, I would strike that sentence. Just take it all out of the picture. If they go and if they go and close on one of your properties, regardless of whether they sign somebody else up in the future or not, they owe you a commission. Does that make sense? That doesn't make sense. Anybody speak up? I'm happy to explain further. As of today, there's no formal termination form for buyer broker agreement. The conditional termination can be broken if buyer later closes on a property shown by the agent. We talked about that. Transaction broker section. So you've gone through all this. Here's I hate to say it out loud, yada, 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 dispute resolution. Here's where you get into the meat of which form you're using. Again, we talked about it, paragraph 12. Broker will act as a transaction broker. And it gives the duties. Confidentiality. I can't come up with a great way to explain confidentiality. And the more I hear people talk about confidentiality and being a transactions broker and your duties and your responsibilities, I've got to tell you, I've been doing this for 40 years, 20 years solo, and it just gets more confusing to me. Here's what I do know. If a buyer, this isn't an upsell, but if a buyer has an attorney and you're in a transactional relationship and you started as a listing agent, it'd be you would have a tough time with a conflicts issue. I can think of almost no thing, and we talk about this in our office. We were talking about it again last night intensely. I can think of no thing that's a buyer's interest that becomes convoluted when you start explaining it to the seller. If you're in a transactional role and you're representing both parties, you're working with both parties. And that's just reality. And I'm not trying to make an upsell, but if you get them, if they're an unrepresented buyer and you're going to get fees on both sides anyways, what's your goal? Your goal is to work as little as possible, make everybody as happy as possible, and get everybody to the closing table. If the buyer has an attorney, that can be your best on-ramp to that position. And again, there are some great transactional attorneys in Palm Beach County that make deals close. They're not road bumps. They're not speed bumps. They make things happen. They've seen a million deals. They know how to put deals back together. Everybody's happier when they're paying commissions and the thing closes versus doesn't close. Sure, the attorney gets paid either way. Not always. We don't get paid a lot of times if a deal doesn't close, but we know how to put deals back together. Does anybody have any questions on that? That's a tough one, but I can see as we move in, and we're going to go into it when I talk about how to how to structure your conversation with buyer's agents on these forms. 13, I'd suggest you have the conversation. So here's paragraph 13. It's a blank paragraph. I'd suggest you have the conversation on seller concessions. Ask if buyer only wants to see properties where seller is listing seller concessions in the MLS. And if so, write in something like broker will only show consumer properties where seller is offering seller concessions in the MLS. This allows agents to legally only take buyers to homes where seller lists seller concessions in the MLS. That is a very controversial statement, which I just told you guys, but I'm willing to go out on a limb with it because I understand the legal issues pretty well. I'm not going to tell you I understand them perfectly. I've heard lots of varying conversations on this topic, but here's what they did by taking the MLS listings of buyers comp out of the MLS. They've given us the ability to ask that conversation, to have that conversation, right? So buyer's agents comp was stipulated in the MLS before, now it's not. So it can't be unlawful if the buyer is now under the burden of buyer's comp to say to the buyer, you only want to see properties where sellers are offering sellers concessions. Now, I didn't say commissions. I didn't say anything about the buyer. The seller can only list in the MLS seller concessions. It's very different than buyer commissions. And I had conversations as recently as this morning with agents not understanding the difference between what I'm going to say, the technical language, the technical nuances in the dialogue, but you have to make sure that you're not saying commissions. You have to make sure you're saying concessions. Does anybody have any questions on that?
Yeah,
So,
no, it's my understanding, Jimmy, that a listing agent can put in there in the MLS that the seller is offering concessions, right, to the buyers,
you
right?
use the exact right word, concessions. Yeah.
Yep. I mean, do they need to, and they can state how much that is? They can
Yep.
put, 3%, right, or 2.5% or whatever.
Whatever the concession is they're offering appears in the MLS. Now, the use of language is important because if your buyer comes back to you and says that concession is for me, how do you make it for you? Then you're going to refer to your stipulation in your paragraph 13 where it says concessions, and we're going to say this is the consistent language that we talked about from the onset. This is where we're going to use to pay my fees. Does that make sense?
Yeah.
I think there could be a disconnect. To state it more clearly, I think there could be a disconnect when naive buyers see that language, and you have to instill early on in your conversation with buyers that when they see that language, that's referencing compensation to buyer's agents. You want to avoid last minute disconnects by having conversations early in the relationship that are going to trigger later transactions where the buyer says, oh, that's what my agent was telling me about in the start.
Hey, Jim.
So it's very important that you use those exact words. Go ahead, Jeff.
You said the buyer's agent needs to make it clear that the buyer understands that the seller concessions is his compensation. What if it comes up as seller concessions in reference to a concession on for a roof, on my side of the
electrical panel repair or something like that?
Yeah, exactly.
Then it's going to have to say to avoid the conflict with your buyer, it should say in the contractor addendum that these are concessions specifically for the roof upgrade or the electrical upgrade or whatever it is.
Doesn't it sound like this hasn't come to an end yet, regardless?
Oh yeah.
I mean,
This is the beginning of a change. The change, I always say, isn't a light switch. A change is a rheostat. It happens slowly. The volume or the intensity gets turned up slowly. I don't necessarily think it's going to get more intense. I think this is one of those things where we have this big hurdle, and then over time, we're going to figure it all out. And within a year, it's just going to be standard fare. There are some things that I think are going to be confusing, and we're going to get to that in a minute. I think this is pretty straightforward. I want to get through this section, and then I want to elaborate a little bit. So this allows agents to, I hate to use the word, but bring buyers to properties that are only offering seller concessions. Use of language is very important. Only offering seller concessions. Everyone I've heard from suggests you read aloud the section on negotiability of compensation. So there's a section, paragraph 14, right before everybody signs. Brokerage commissions, and this is what I've heard from the people who discuss this thing at a lot more detailed, higher level than me. They suggest you read it aloud to your client. Brokerage commissions are not set by law and are fully negotiable. Broker may not receive compensation from any source that exceeds the amount or rate agreed to with the consumer. Get them to sign. You need the name, address, and phone number, and a copy of the driver's license. Love the Florida Realtors disclaimer. You guys, this stuff, I cannot tell you how much this nauseates me. I'm going to try to make it a little bit bigger. Florida Realtors makes no representations as to the legal validity or adequacy of any provision of this form for a specific transaction. Mind blown. I saw a closing document from a law firm I used to use over and over and over. And people would call me and they'd say, "Why do I need a lawyer?" And I would read aloud the last sentence of the closing document from this law firm that probably closed 100 deals a day throughout Florida. And the last sentence read, and I'm not exaggerating, "The closing agent is not responsible to record curative instruments such as satisfactions of mortgage, discharges of liens, et cetera, et cetera. It is the client's responsibility to ensure this has occurred and bring it to the attention of the closing agent if it hasn't." That form was signed 100 times a day by buyers and sellers. Blew my mind. Every time I would see it, I would absolutely object, and the law firm, the closing agent, would strike it. It was a law firm. It wasn't just a title company. It was a law firm title company. This is on that same magnitude. Don't want to labor over it. I just can't even believe they would put something like that in writing. What are you guys paying for? That's not rhetorical. What are you paying for? You're paying for being guided. Now the people who are guiding you are telling you if they have to, they'll pull the rug out from under you. I usually don't go hard on something like this, but yeah. Who was it that said this isn't over? Who was it, Jeff? Yeah, Jeff, this probably isn't over. Which form do you use? I call it number two, the form that I've heard most educators and brokers saying they're going to have their agents start with is the transaction broker form. I call it number two in the list. It's the one we just went over. It's the one at the top of page 3 that's identified by the provision that says broker will act as a transaction broker. Anything else?
Yeah, just a couple other things here too. Valerie had asked, can we specifically state the seller's concession will be used towards buyer's agent's compensation in the contract?
You can do it in the contract. You can do it in your websites. You can do it in emails. You can do it in texts. You can do it in communications, but you can't do it in the MLS. In the MLS, from what I understand, the new box, the dialog box, is going to say seller concessions. You can't, in the broker comments or any place else, have a statement that says buyer compensation.
So
But can you put it, can you say seller concessions on the MLS?
Yep.
And does that have to be designated for what that money is to be used for?
It can't be. My understanding, it can't be, right? It just says seller concession.
Well, you could say, like, let's just say the house, don't ask me why anybody would do this, but you could say their seller is offering a $20,000 seller concession for roof replacement. Only cash offers allowed. That's not unlawful. That's not a problem. That's completely within the context. Within the rules and the proposed settlement. The settlement still hasn't been ratified by the High Court. That's still in the future.
Mhm.
Bear that in mind. But the way it's written right now is the seller concession statement can't have a corollary statement to buyer's compensation, buyer agent compensation. Even I get
That's BS though, Jim. You know what it is. You're saying the same thing and you're not saying it.
Yeah, 100%. And that's, I'm going to go out a little bit on a limb right now, Jeff, and I'm going to tell you that's why the High Court hasn't approved this thing yet.
Yeah.
They want to see what happens in execution. And although I think that the volume of communication on this topic is good, right? And the ability for us to communicate effectively through social media and things like that and dissemination of information is great. Don't think for a second that the Department of Justice and the plaintiff's lawyers and the regulators aren't listening to that same social media going, they're trying to beat us. How do we beat them trying to beat us?
Mhm.
That's why there's no end to this right now, because there's going to have to become to some resolution that makes this way more simpler and transparent. It's not as confusing for a new time buyer, first time buyer. This would like blow them. I mean, they're going to be so confused.
I don't disagree, and I don't want to alienate any agents that I've spent my professional life making relationships with, but if a buyer goes to a buyer's agent and that buyer's agent immediately starts talking about the different forms and the lawsuits and the things, and you got to sign this, the first thing a buyer's agent's going to do is recoil, go to Zillow, find the listing agent, call them directly.
Well, this is one thing here. What is this? Ginger asked this question, and Angela had her hand raised as well, but we want to get to Angela as well. What if they refuse to sign? Like, what if the buyers refuse to sign the buyer's broker's agreement? What happens at that point?
Things you have to keep in mind. Where was it? I don't remember where I put it.
Yeah, it doesn't protect. This is for the agents. It's not for the buyers. That's what I'm saying. So, like, if they
What happens if the buyer doesn't want to sign? Then the agent can't.
But you don't work with him.
Go ahead, Pablo.
I mean, if they don't want to sign to pay your commission, you don't work with them. Just find somebody else.
There you go.
That's it. Don't waste your time with people that, this is my opinion. I'm sorry to interrupt everybody. Don't waste your time with buyers. They're not going to appreciate your time. If you see the buyers that are reluctant to sign and you have to convince them, I wouldn't spend time or a minute with them. I would find a buyer they understand the value of a realtor, and we have to explain them. And if they do, you work with them. And if it doesn't, you go find somebody else. Simple as that.
Yep. If the buyer won't sign and you're a NAR agent, then you can't work with them.
Yeah, I personally don't believe in retainers. I don't believe in cancellation fee. If you cannot trust the buyer, or seller, don't work with them. Simple as that. Work with people that you trust
before August 17th.
Right. Well, work with people that you trust. They will pay you. They will understand what you're doing. If you cannot trust the person that you're doing a buying or you're doing a selling or listing, why are you going to waste your time with those people? You don't. You move on and you find somebody to do. They're going to make your life easier. My opinion.
All right, Angela, I just want to get to you. You had your hand raised. You still have a question, Angela?
Yeah, I was just wondering about the Zillow situation where they're telling their consumers that they could sign a 1-week trial of working with an agent, and how does that fit into compliance with our current forms?
Yeah, so Zillow's making a showing agreement available. We had a podcast on it not too long ago. And so the showing agreement says that there's no compensation due when they get this little period of time and they go out and show properties. The law says, the rule says that you have to have a written agreement with your buyer from a buyer's agent perspective. You have to have a written agreement with your buyer that stipulates the compensation. If the compensation is stipulated as zero, you've stipulated the compensation, it's zero. But it can't be zero and now you want to collect the fee. Some brokers are telling their agents, you want to show somebody something on the fly, you go get you just print out the Zillow form and get the showing agreement. Other brokers are telling their agents, go out and get the showing agreement signed. They're professional decisions you have to make on how you want to conduct your practice. Do I suggest that the showing agreement is a great form? No, I don't like it. But I think that Zillow's making a lot of noise that will drive agents and buyers and sellers to Zillow, which, is valuable to Zillow. It's not valuable to us. Did that answer your question?
Yes, thank you.
You're welcome. Anybody else? Anything else in the comments, Ryan?
No, I think we covered a lot of it. If anybody has any questions, it'd be good, raise your hand and we can get to them.
This showing agreement form is going to be revised. It's going to be, supposedly it was already revised, but supposedly it's going to be revised again.
Go ahead. Monica has a question.
Yep.
Not a question. Well, yeah, a question. What happens if the buyer signs multiple contracts, and how would that affect them? I know that they would owe a commission, but how would we get our money?
Well, the question I thought somebody would ask that wasn't asked is, what if a buyer doesn't pay the commission, ghosts what if a buyer ghosts the buyer's agent or refuses to pay the commission at the closing table or can't pay the commission?
Wow.
Your question is, what if a buyer signs multiple buyer engagement agreements, which is completely probable, possible, plausible. And the easy answer is the buyer would owe multiple commissions. The hard answer is, how do you enforce that? Again, small claims is up to $9 grand. I've heard lots of brokers say they're going to go after their commissions. We're professionals just like CPAs or lawyers, and we're entitled to our fees. The hard question for me is, if you're at the closing table and the buyer refuses to pay and the seller's not paying, and at the last second, the buyer says, I can't or won't pay, does the closing stop? I would tell you it doesn't. I would tell you that a buyer at the closing table who refuses to stroke that check to the buyer's agent doesn't stop the sale from occurring. Now, that doesn't stop the buyer's agent from going after the buyer under contract law. And I'm sure there are going to be a ton of attorneys. I shouldn't say a ton. I'm sure there'll be attorneys that will advertise, were you duped out of a commission, split it with us and we'll get it with you, or whatever it's going to be. It'll turn into its own little practice of law. But I don't think that holds up the sale. And if somebody,
you don't think there could be a cloud on the title? I mean, could there be is there a mechanism for an agent to put a lien?
not in residential transactions. No.
So maybe it's good to get a retainer.
Do I think every single buyer's agent August 18th is going to get a buyer's agency agreement form from every buyer that sits in front of them? Absolutely. There will absolutely be buyer's agents who do not get this signed.
Which leads me to a question on this, Jim.
What's the enforcement? What's the
what's the
penalty?
enforcement? Like, who's enforcing this? And then what are the repercussions of the, for instance, that people don't get them signed?
Right. So I don't know what the damages are. I don't know what the hurt is. I can see a couple of different enforcement mechanisms, and that's going to be plaintiffs' attorneys that are no longer involved in personal injury cases, sliding into real estate. If anybody needs to sign off, I won't be offended. Don't feel like you guys got to hang out to the bitter end. but you know, what are plaintiffs' attorneys' goals? The goals of a plaintiff's attorney are always to get into somebody's insurance policy. Who carries insurance? Brokers. That's where they want to get. They want to get into those pockets. Yeah, E&O. And there are a lot of brokerages. I've had conversations with small boutique brokerages that don't carry insurance. I would suggest you guys carry insurance. I think that's really, really, really important. Small brokerages may think that it's very expensive. We work with a company, National Risk, and they were telling me, and I've lined up broker policies for small brokerages. It's not that much money. You know, the other discussion that.
Yeah, no, if you're an agent, ask your broker if he carries E&O insurance, because this is, I mean, obviously, you know, would be a mechanism where attorneys, if they're going to go after this, they're going to try to get the money and they're going to go after the insurance company.
Well, Tajay and I were batting around another topic last night that I thought might come up, but didn't, is that is the broker responsible? Like, there's a lot of forms now. And historically, if you were a buyer's agent, there was only one form, the contract. There were more forms available, but you didn't really have to shepherd your buyer's agents and make sure they were doing their job from a forms perspective. Now there's a bunch of forms. And is the broker responsible if all those forms don't get in the file for that agent?
Hey, Jim, does the buyer's agent fee become closing costs? And if it is, would that hold up to closing because money is not?
Let's just say it's on the, and I would imagine it would be, let's just say that the buyer's fee is on the closing disclosure or the HUD if it's not a loan. So now you've got the fee on there and it's $440,000 and $10,000 is for the buyer's agent or whatever the numbers work out to be. And the buyer shows up with all the money less the buyer's agent fee, that exact value. Now what?
Yeah. So
$6,000 is the carve out. No, I just want you to have that visual in your mind.
Yeah, I know.
6,000 is the carve out for the buyer's agent. And they show up instead of with 440 grand, they show up with 434 in a cashier's in the wire. The wire is for 434. What do you do?
Yeah.
But would that truly happen if the closing company, because it doesn't the buyer get the final figure from the closing company, and the closing company would have received the buyer brokerage agreement from the listing agent, from the buyer's agent.
There you go, Jim. For your title company now, you're going to want to see the buyer's agency agreement now with every buyer that has a rep of an agent.
Well, that's something that we were talking about, Tajay and I and Christian were talking about last night. Is that our duty? It's not necessarily our duty. We get a DA, we get a distribution authority from the broker. How far do we need to dig? We get the DA, we throw the DA in the file and we just disperse based on the DA. Suppose the DA says $6,000 to the buyer's agent. We put it on the settlement statement, $6,000 to the buyer's agent. Again, the buyer shows up. Alberto, I don't want to downplay your statement. I think your statement is relevant. I think it's germane. I think it's vital. But let's just say the buyer everybody's been told the closing fee is 440 grand. Everybody, and no one said anything. And now you're on the eve of closing and the buyer only wires 434. And the exact fee to buyer's agent is $6,000. Now what?
But isn't it part of the contract?
It's the contract is between buyers and sellers.
Right. Well, I recently
Not
started
between buyers, sellers, and agents. And that goes to Ryan's point earlier about commercial forms where everybody signs.
They need to do it like commercial. Commercial is so easy. It's literally right there in the contract that says who's paying the commission, whether it's the seller or the seller's agent, and it's spelled out right there.
But even if the contract stipulates it, unless that form is signed by the agents, it's not binding on the agents. I can write a contract with you, Ryan, that I'm going to pay you $1 million by the end of the day. I can write a contract with you that I'm going to pay you $1 million by the end of the day. I can write a contract third time. I can write a contract with you that says I'm going to pay Pablo $1 million by the end of the day. Pablo can't enforce that.
But the purchase contract, if you put it on the purchase contract, is what I meant.
Yeah, you have the purchase and sale agreement. just like it is now. And at the bottom, it says 3% is going to go to the buyer's agent. Buyer's agent can't enforce that if the buyer's not going to pay it or the seller's not going to pay it. If it's not, you're not, there's a thing called privity and you're not in privity. It's not, yeah.
Yeah, we're not a party to the transaction,
You're not a party to the contract.
to the contract.
Yeah,
Yeah.
you guys have there's the principal transaction, which is the purchase and sale, and then there's ancillary transactions, which are the relationships between the buyers and the sellers. I'm sorry, between the buyers and buyers agents, sellers and sellers agents.
Which goes down to that compensation agreement. Like if it's there and and the listing agent goes, hey, the seller's going to pay you 2.5%, get that compensation agreement from the seller to the buyer's agent at 2.5%. Then you have that document, then you're protected. Then you send it to title and say, hey,
More documents, more headaches, but that's what it takes.
And I just wanted to share something that I recently did because I started implementing the buyer representation agreement immediately. And so I recently had a buyer sign a representation agreement at 3%, but the commission offered on the MLS still is only 2.5. And I already reached out to the title company and I forwarded them a copy of the buyer's representation agreement that the buyer is going to be paying that difference between the 2.5 and the 3%.
So the DA is the thing you want to send over, but understood. I understand what you're saying. And so that other 0.5 is going to be coming from the buyer themselves.
Correct.
And so, yeah, that's in Tajay, you got any thoughts, or Christian, you got any thoughts on that? So there should be a DA that says 3. I almost feel like there's got to be I mean, there's already a buyer's agency agreement that says 3. So
which it's to not exceed. So if you're signing the buyer's agency agreement form, you should put everybody at 3%, because it would be a shame if you put 2 or 2.5 and
exactly
the seller's offering 3 and now you just walked away from the point.
To Alberto's point, though, I think there's a lot of competition, and so if a buyer visits 2 or 3 buyers agents and they're asking for 4, the next buyer's agent that they visit that asks for 3, they might go like, oh, this is a discount. But I think that it's important for us to put the buyer's agency fee as high as possible.
Mm-hmm.
Start at 3. Now, the other question that nobody asked is, what if the seller's paying 3 and the buyer's agency agreement says 2.5? Now you have to have the conversation about that was intended for me, and can we ratchet this up, Mr. Buyer, Mrs. Buyer, to 3% for me? If you've shown them 1 million properties, and we had an agent in here the other day that showed a buyer 36 properties and they still hadn't committed, I don't think that's a hard sell. Again, it's restating your value proposition. It's at the beginning of this thing, you're going to be like a listing agent. I push title advance. You can use title advance as something that you're going to use to distinguish yourself with other buyers agents. So when your buyer comes in and you may or may not know they've talked to other buyers agents, you can tell them you use a tool called title advance, and you can show them what title advance is. We're actually going to get title to your property before you make your offer, just to make sure we're not making offers on properties with convoluted title. And you can show them our website, and you can wind and through them and with the tools that you guys have access to. It's a matter of distinguishing yourselves from the rest of the buyers agents in the world.
Question about title advance. So is that kind of like a lien search? Because I had a recent transaction that fell through during the municipal lien search period because it had over $800,000 worth of code violations. And of course, that was after the fact that the buyer already did their inspection period. They already paid for the appraisal. So does title advance prevent us or at least give us an indication of the code violations that a particular property has?
Yeah, the majority of municipalities make that stuff available to us. Some don't. If the municipality doesn't make that stuff available to us, the title advance will say that it's not available. And we've cut off many problematic transactions because there were issues just like what you're talking about. So most of the time, yes, title advance will show you those problems. Now, if it's to such an extent that it's become a lien on real property. So there's code violations. So this is an important digression. Again, if anybody wants to sign off, I'm not going to be offended. You have two records. You have the municipal records for municipality and county, and then you have the public record. Deeds, liens, and mortgages go in the public record. Deeds, liens, mortgages, judgments go in the public record. Open permits, code violations, fines for tall grass or violations for tall grass and things like that go in the municipal record. In order for something to jump from the municipal record to the public record, it has to have been ruled on by a judge and a lien start. So when you have situations like, I saw one the other day, somebody didn't have a rental license and they had a violation, they had a code violation for failing to get a rental license. That exists in the municipal records. That will be showed most of the time in a title advance. If a judge rules on it and it becomes a lien being imposed daily, now it jumps to the public record. Title advance will always show that. Does that answer your question?
Yes.
Little digression.
Thank you.
Oh, the other thing I want to say before we move on, the public record is handled as a title matter. The municipal record is handled as a contract matter. So agents, if you have a good title agent, they're going to help you with the municipal record issues. And if you have a title agent that has a law firm, they can use the law firm to get stuff done. But those aren't title issues and they're not handled by the title agent. And they're not going to be resolved by sellers for the most part. Federico?
Yeah, thank you, Jim. I had this a similar situation. It was discovered title advance report. I went to the city and I was locked. I tried to negotiate, but the city waived it, completely waived it, the $100,000 penalty fee that I had. So
I was gonna say that I wasn't able to see. Hi everyone. I wasn't able to see what agent said about the $800,000 lien, but Pete, you could always mitigate those things. It's not that the deal can't close. In Fed, that's a great example. I remember you did have that one where there's $100,000 lien and you went and got it mitigated through the city.
The key here is that the seller was a senior citizen, and it was like
senior citizens are tough to convince sometimes. They don't get it. Courts love senior citizens if you go in front of them with good facts and good, a good story. Judges like to give help to senior citizens. We had a senior citizen, they were selling a property they received in a divorce. In the divorce, the seller, before the divorce, the husband had all kinds of code violations and there was ongoing liens and it was $276,000. We got it reduced down to pennies. And it was because she was senior and the facts lent the judge to giving a very favorable decree. But what Tajay said is important, and I'm going to give you a self-serving plug. We have a law firm and we have a relationship with 2,000 or 3,000 agents. Those guys are all out in the community scouring title for us. We get a title advance that's dirty. It's a great opportunity for us to clean up title and close a file. If you guys have properties that you have that have problematic issues, text me and we'll figure out what the resolution is. If we can get that thing resolved and close the file, that's the way you want to do it. We used to get a ton of work from other title agents. It hasn't been recently, but we used to get a ton of work from other title agents that said stuff can't close. And then we'd use the law firm and figure out the issue, mitigate the lien, and then get it closed. All doable stuff. Any other comments, Ryan?
Wow, Jim. I mean, I just want to, if there's any other questions, people go ahead and feel free to raise your hand. But wow, what an important topic. And like I said, I've listened to some other podcasts, Jim, on this issue, and this has been the most concise and best information that I've seen. And I do want to give a quick plug for Jim on a personal level. I'm an agent out there. Obviously, I have Real Trade as well, and I want you to check out. But Jim, with what he's done with New Path Title and Title Advance and his closing software, Title Leap, is so much different than every other title company that I've used. And I'm a buyer's agent. I work with a lot of buyers, and I've tried a lot of other different title companies. It saves you so much time, this Title Advance. I mean, if you see a title issue and you can have that off at the pass, and it's a free service that he offers to agents. It's amazing. Of course, his closing software, Title Leap, is like a free contract coordinator. Again, it's free for agents, and it keeps track of all your drop dead dates and the progression of the closings, so you have no surprises as you go through the transaction, which is awesome.
And if you
obviously,
guys are on the buy side and you use Title Advance and you get a contract, you can just write us in paragraph 20, the closing agent is New Path Title. Leave the seller paying for title. And now the closing agent will be us, and you'll get Title Leap and you'll get all the other benefits we give you guys along the way. There's no law in Palm Beach County that says the seller has to pay for title. Who pays for title is an election in the contract. Typically, Palm Beach County, it's the seller, and so in the paragraph 20, you can write the closing agent, capital C, capital A, is New Path Title. Now the seller will pay for it, and it's going to be us, and we can have that conversation along the way about shepherding the deal if any problems come up.
And Jim, I wanted to add something really quickly about everything we spoke about today. This is just my take. We handle a lot of closings here in our office. My biggest piece of advice to agents would be, if you're working with a buyer and they have a lender, you should be in contact with that lender before you even sign anything. Reason is that I already see a whole bunch of disconnect as far as, the roof credits and can it show up on the settlement statement and all these different pieces. So just adding in the commission piece to it should definitely be speaking to a lender and letting the lender know what you're going to have the buyer sign, how you're going to show it on the settlement statement, all those things. You don't want on the day of closing, the lender says, oh, sorry, the buyer can't get a $9,000 concession from the seller. You just want to make sure that the lender makes the final call and makes the final rules. So make sure you're talking to that lender early on in the transaction. The buyer can tell you whatever they want to tell you, but that lender is really the person that dictates how it gets done.
You guys, title agents are like a lifeguard, right? We get to see everybody in the pool. And I've used this analogy before. If you don't have a best friend that's a title agent and you're a realtor, you're missing out. Because the title agent can tell you about a million other deals that have gone well or bad based on the same facts you're looking at. A guy like Tajay is looking at deals day in, day out. Christian is scrubbing deals day in, day out. They see where things go awry. You can ask all the other agents you want to ask, but there's nobody who gets to umpire deals like we do. So you see something that's possibly a problem, text me 24/7. I'll give you guys the answer that'll get you on the straight and narrow to the closing table. No need to have the pain anymore. If you don't have a best friend that's a title agent and you're a real estate agent, you're missing out. I'm looking for friends.
awesome. And speaking of friend, I do want to plug Real Trade, guys. It's an online marketplace and social media platform for real estate. I tell agents you can sign up there, get free leads. Buyers and sellers can contact you directly off your own listings, or they can discover you as a buyer's agent on Real Trade from the social feed and also Search Pros feature, which buyers are doing right now. So that you can check that out. It's pretty awesome. It's free for agents to sign up. And like I said, you can not only get connected with buyers and sellers, you can get connected with awesome service providers like Jim. He's active on there, and you can get connected with awesome lenders on the platform as well, like Jeff Stewart, who's on this call. So definitely check that out.
You guys, Ryan's always pumping us up. I got to take more time to pump him up, but I will tell you this from the heart. If you have a property on Real Trade and you get contacted by a buyer directly, you're going to get the double dip. It's as easy as that. It's the home of the double dip.
Yep. It's pretty awesome. I get calls from agents all the time. I actually met one on a showing that I was showing her listing, and she said, "Oh, you're for Real Trade, Ryan Poole." And I said, "Yeah." And she goes, "No, I actually got a deal from your website. Thank you so much." So I mean, I didn't even know about it, obviously, because we can't track. We actually share the agent's information public on the website. The buyers, sellers don't have to be registered to see that. So that's pretty awesome.
How many agents do you have on the platform now?
2,500 now, Jim.
When we met with you, had 400, and the stories of off-market deals are countless.
Yep. And you can promote everything there, from your open houses. You can do live listing updates. You can post buyer needs. If you're working with a buyer and you can't find inventory for that, you can actually post that. It's an awesome feature on Real Trade, and all those listing agents out there that are trying to close deals, you can help them close a deal, and you can put a deal together. So it's a pretty awesome feature, and a lot of agents are taking advantage of it. And best thing, like I said, it's free for agents.
Now it's the way things are evolving too.
Yep.
Absolutely. Real Trade is the way things are going to go for agents, for sure.
Ryan, are you gonna have commercial listings?
We do have commercial if they're put on the MLS, but we were actually working out a way that agents, you know, because a lot of there's obviously Crexy and LoopNet and other CoStar and other platforms, you know, where people can do commercial listings. So we're working on trying to implement those as well.
Mm-hmm. Very nice.
You guys, it's been a pleasure seeing all the new faces we've seen today. I can't wait to do business with you guys. I don't want to cut this off. If anybody wants to sign off, they're more than welcome. I won't be offended. If anybody wants to hang out and still talk, I'm happy to entertain additional conversations. This has been, wow, are we
We're 2 hours, Jim, just about into this. I mean, it's such an important topic. I mean, like I said, 20 years of doing this. I've never had anything. This is like a seismic, you know, earthquake in the industry. And it's going to be, like I said, it's going to be interesting to how it all works out. I think your analogy, Jim, with it being a rheostat and not a switch is very, you know, that type of analogy is actually in my mind. And I think it'll work out over time. But in the meantime, it's just us agents have to keep up with the information as best we can and try to do the right thing.
a rheostat's a dimmer, right? You walk into the room and it's dark, and then you slowly turn up the light. The light switch, you walk in and it's instantly light. It's gonna
You're
take
part of that light, Jim. You're part of that light, putting some light on for us agents and helping us work through this transition. It's pretty
gonna
awesome.
take a little time to make that room bright.
Yeah.
All right, you guys. It's been a pleasure. The best part of my week is always talking with you guys.
All right. Thanks, everybody.